everyone. Is the scheduled time and we have already formed a quorum. This is the Bills Committee on Land Miscellaneous Provision Amendment Bill 2014. Item 1 on the agenda, we have to elect the chairman for the Bills Committee. Any nomination? Dr. Lo Wai Kwok. I'd like to nominate Tony Chair. Do you accept the nomination? Yes. Any seconder? Elizabeth Kwok seconds. Any other nominations? No? Okay, so Tony Chair has been elected chairman of the Bills Committee, so please come over to chair the meeting.
好啊，多謝大家嘅支持同埋。
Thank you for your support. Do we need to have a deputy chairman? No, not necessary. Then we can immediately move on to the agenda proper. Let's invite the administration team to join us. Welcome to the administration team. I think members have all got a list, the list of government officials attending the meeting. I don't propose to introduce them here. So can you please walk us through the bill before we start the discussion? Yes, Ms. Choi. Chairman, before us today is in 2012 because of the Audit Commission and also the PAC of this Council in the number 58 report with regard to unlawful occupation of unleased government land. There were some recommendations, and now we are going to amend Cap 28 Land Miscellaneous Provisions Ordinance, and we propose to increase the fine level, and also we'd like to introduce a system of daily fine in order to enhance the deterrent effect. The administration accepted the recommendations of the reports. In fact, the law was introduced in 1972, and since then the penalties have not been reviewed and adjusted. We believe that the current level is not able to reflect the severity of the offense, and it doesn't have enough deterrent effect. That's why we are proposing to increase them. Given the fact that land is a scarce and valuable resource in Hong Kong, therefore we believe that it's important to ensure that the penalties should be high enough in order to enable us to impose land administration properly. And there are three areas of amendment. First, unlawful occupation of unleased government. Second is the unearthing or the second unlawful structure being erected on unleased land, and third, removal of earth, turf or stone from unleased land without a removal permit. And we would like to change, we would like to make reference to Cap 123 Buildings Ordinance and Cap 354 Waste Disposal Ordinance, and also Town Planning Ordinance 131. In particular, with regard to the Buildings Ordinance, some of the provisions are particularly useful because, after all, for the planning mechanism and also the land administration system, they are very closely related under Cap 131. Section 23(1) with regard to unauthorized development without notification, and also the termination of unauthorized development. That is a basis for which we would be making reference to. With regard to the specific content of this bill, I'd like to raise a number of points for members to consider. We would like to propose that certain things remain unchanged. That is under Cap 28. We have to put up a notice under the current mechanism, and if we notice that there is unlawful occupation of unleased government land, so under the system we first have to put up a notice, and within a specified time, if that is not rectified, that would constitute an offense, and then we will proceed with prosecution. And we believe that that framework should remain unchanged. And what we'd like to keep is that with regard to the three offenses, and there are different levels of there are different maximum fines. So even if the maximum fines are increased, we'd like to maintain the ratio, and therefore if it's a change from 5 to 1,000 or 1, and then we will have to maintain the proportion. And also with regard to the minimum amount, that would also be kept. We would also like to introduce a system of daily fine. With regard to the amount to be set, we believe that for the maximum fine, so for the daily fine, it will be 1/10 of the maximum fine. And we would also like to introduce the idea of a first offense and also subsequent repeated offense. Well, for first offense or first-time offense, the maximum level should be lower, but then for subsequent offenses, the maximum fine should be higher. And also under Cap 28, we have already provided that the administration can recover the cost of demolition of the unauthorized structures. And we would like to say as well that under application, the court may, or the court could also take the initiative to require the convicted party to refund the administration or the authorities for the cost incurred. We have consulted the development panel of this council, and basically is supported. But then on the 22nd of April 2014, members were concerned about the enforcement effectiveness, and I'd like to respond by saying that the Lands Department recently conducted a review on the land administration system, and there was some enhancement measures in enforcement action. For example, the routing and also the inspection would be updated and increased in frequency. And then for unauthorized works underway, while they are underway, more stringent demolition or removal operation will be carried out, and there would also be step-up training for inspectors and also frontline staff. And we have just introduced a series of APIs both on radio and TV in order to enhance the awareness of the public. And the message is for unauthorized structures and unauthorized or unlawful occupation of unleased land, the consequences could be dire. So that's all I'd like to say for the time being, and I'll be happy to take questions. Okay, the floor is now open to members. Dr. Lo Wai Kwok. 5 minutes, including questions and answers. Thank you, Chairman. Well, the ordinance was introduced in 1972, and even if you just take into account inflation, and structures on land have increased in value over the years, and that's why I believe there is a need for us to amend the penalty in order to catch up with time. But then what's important is also the corresponding power given to the Lands Department to take enforcement action to prevent and deter such actions. So it has to be done in a timely manner. Other than issuing a notice, what's more important is to demolish the structure. So I'd like to know what's the progress. Is it that there has been limited manpower, and therefore it might be too slow in taking action, or that it's not possible, and in the past people would just take it as a form of rent? So what is the latest situation? Yes, Ms. Lam. Thank you, Chairman. Generally speaking, if there is unlawful occupation of unleased government land, as you said, we would put up a notice requiring the party to demolish the structure, and if the party fails to do so, then we will arrange for our contractor to clear the structures. So in this regard, there is no question of the party gaining any benefit because we will enforce the law by removing or demolishing the structure on the land. Yes, I understand that you do have that statutory power to take action by demolishing the structure, but then I'd like to know what's the actual situation on the ground. Is it that you're able to do so in 100% of the cases, or is it because of certain constraints that there has been some delay? So I'm giving you a chance to air your grievances. So please be frank with us and just let us know what your difficulties are. Well, very often after putting up the notice, they would just remove the structures themselves. Is that the case? All right. So we have about 10,000 or so such cases, and then in 2,000 to 3,000 cases, they would just remove the structures on their own volition. All right. You can also provide the figures to us after the meeting as regards the enforcement figures. So how can you show that in the past your enforcement has been effective? Because we are also concerned about both. That is about whether or not the law is effective and whether or not your enforcement has been effective. Well, let me give you the figures. In 2013, there were 2,463. They removed it on their own, and then we removed 2,349, and then there were some 2,400 such cases in which we have to tear down the structures together with other departments. So the total was 7,358. Well, on different occasions, as we have said, with regard to law enforcement, we have a lot of land. That's why it's not possible for us to conduct a territory-wide inspection of all the sites in Hong Kong, and therefore we can only act on complaints and referral, and then we will inspect the sites and the premises. And in response to your question, upon receipt of complaints by the Lands Department, they will definitely take or go there to conduct an inspection. So there is no question of not going there to take a look. And then after the inspection, that depends on the situation. Sometimes after the Lands Department has put up a notice, then the party would cease the occupation. And in some cases, the Lands Department and the relevant department will have to take joint action against the party concerned. And as Ms. Lam just provided you with the figures, and as some of you might have seen, well, in the course of enforcement action or management measures, there might be different outcomes. And if you're interested in getting further details, we can provide you with further details in writing. All right, I still have some time left. Okay, these are past figures. So 2013, 7,000 plus cases if you add up all the figures. But then there are many more cases being hidden in the territory. There was no complaint and you were not aware of those cases. So do you have any estimate on the actual number that were unreported or unidentified? Well, we can provide you with further details with regard to unreported cases. Well, that would be somewhat difficult because in the course of our inspection for the cases that we have managed to identify, we can provide the figures. But then, after all, it's not possible for us to inspect all the places. But then we'll try our best. Well, in some cases, you identified the problems during inspection. Others, you received tip-off or reports. Well, Chairman, actually, you can give us some estimates. Well, are we just talking about the tip of the iceberg, or is it that basically we've been able to deal with most of the cases and the remaining ones would be very small in number? So can you give us an idea?
Next, we have Mr. Wu Chi-wai. Thank you, Chairman. The bill is simple is technical. It's about increasing penalties. The bill only targets government land, if I understand it correctly. I hope the Bureau or the administration can elaborate on the application of the bill in relation to land use, on government land and private land, and what are the differences of the application approach. Second, on enforcement. In March and April, in the development panel, we discussed law enforcement, and the government replied that inspection had been improved, the routing, the training had all been improved. But people do see it very differently. I have an example, a case in relation to Kawa King. And there are some barbecue grounds there, which is against the lease. The Lands Department issued a warning letter, and then there was no compliance. And then, well, the letter was sent last year. And 10 months later, we were told this year that action will be taken, further action will be taken to enforce the lease. The time gap is so long. I would say that the effectiveness of enforcement is very low. In this case, we're talking about privately held land. Is there a deadline for enforcement action in relation to private land? And likewise, what about government land? Do you have a timetable? For example, I put up a notice, and then after 14 days, I'll do this, and if you do not comply, I will do another thing after a certain period of time. Do you have a system like that? Let's talk about government land first. We'll act according to Cap 28. We put up a notice. The notice will allow the other party, the occupier, a period of time to cease the occupation. And the period allowed is dependent on the situation. Of course, we want the occupier to move out as soon as possible. If there's a dangerous situation, the time allowed will be very short. If it takes time to remove things, then the period will be longer. And after the period expires, we send our staff to take a look. If the structures are still there, or if we cannot identify the persons, then we'll ask our contractor to do it for us. Can you tell us the time frame? From the time you put up notice till the time your contractor goes there to remove the things, how long will it take? Well, it depends on the case and also the nature of illegal occupation. We allow different periods of time. Maybe you should ask what's the normal duration. Well, there's a logical problem. You'd allow different periods of time according to the complexity of the case. If I occupy your land extensively, you are going to allow me more time. But I would say that if it's an extensive illegal occupation, you should allow me more time. Well, if it's a serious unlawful occupation, we'll ask the occupier to move out very quickly. If there's a dangerous situation, or if the illegal occupation is serious, we'll ask the occupier to move out quickly. For example, for skip, we will put up a notice on Monday, allow it to stay until Tuesday, and on Wednesday it must go. On Thursday, we would do the inspection. Usually, if it's a skip, it will be removed. If the skip is still there, we'll ask our contractor to remove it right away. If a demolition is required, then, well, can you tell us some breakdown figures with respect to different cases? Can you give us some figures, representative data of cases of different nature? And then perhaps you can then later address the questions about private land. Mr. Chanakan, the speaker's not coming through. The bill introduces the idea of continuous offense. How is this going to be applied? If someone is guilty of the offense under 4AA, and then they receive the warning, and the ratification is done very quickly, maybe the skip is removed, but you cannot just make a phone call and remove it right away. It may take 1 or 2 days. So when will the continuous offense start to count? From the time the notice is put up, or from the time I call my contractor to remove the skip, or after the skip is removed? It's counted on the basis of 1/10 of maximum penalty. So when does it start to run? After the skip is removed? So what's the definition of this concept of continuous offense? What's the definition? Well, we don't start to count the time when the notice is put up. So let's say this is an unlawful occupation. There are some illegal structures, and we'll give them a number of days. So during that period, there's no continuous offense. After a number of days, and the notification period expires, and still the illegal occupation has not been ratified, then that's the first day. Of course, we need to collect evidence. And for every day when the offense persists, then the maximum penalty is 1/10 of the maximum penalty. And it's just the maximum. Say I have received the notice on the last day of the grace period. I did call someone to clear the structures, but there was a typhoon, signal number 8, and it could not be done. So would time start to run against me? Because we do have this force majeure idea, act of God. Because these companies which own the skips tend to be small and medium-sized companies. Chairman, there are 2 questions. Under the bill, we frame the provisions by saying that without reasonable excuse, blah, blah, blah. So the Lands Department will certainly consider cases where you have so-called force majeure and other circumstances. As for the continuous offense, I just want to supplement that under the current law, when are you going to commit an offense? When the relevant party, without reasonable excuse, does not cease to occupy the land illegally. And even under the bill, we adopt the same spirit. And that is the unlawful occupation continues after the period concerned. So we'll not start to count in the very beginning. And then if we prosecute, there's a process. And of course, every case is different. So how would the court rule or judge the case? It depends on the individual case in question, generally speaking. So what is the definition of an offense? Under the amendment bill, there's no change to the existing law. Mr. Yip Kok Him. Thank you, Chairman. With regard to illegal occupation of government land, we have received complaints, and we do see offenses, and we find such illegal occupation unreasonable and unjustified. So what provisions in the bill can offer you the biggest help? The increase in penalties? Or is it the case that your manpower is such that upon receipt of complaints, and some complaints are received by members, you could do nothing in respect of most of the cases? So to what extent can the bill, or which provisions in the bill can offer you the biggest help? And some cases are legacy problems. And that is to say, there were problems that can be dated back decades, especially some cases in the NT. And there are long-standing problems that you have not been able to resolve for a long time. So it's not a question of right or wrong. There are many disputes in the NT. Views may be divergent, and they may have to do with village development. Will the new approach create conflicts? And in some cases, you were more lenient in the past. Would that change with this bill?
就住個罰款嗰度，而家我
On the question of the levels of fine, we want to increase the amount and so as to achieve a bigger deterrent effect. Mr. Yip also asked whether in terms of enforcement we have sufficient manpower. I'll ask which provision or provisions can offer you the biggest help in the bill. We believe increasing the penalties in the levels of fines will be one of them, because the amount, the levels was set decades ago. Is no longer a deterrent. But we don't have any statistics or projections as regards how effective they're going to help us. As regards enforcement difficulties or manpower, well, actually, yes, we deal with different cases according to priorities. For example, Ms. Lam has talked about cases whereby personal safety or pollution or nuisance will be involved, or maybe there will be damage to property. Those cases will be accorded priority. Or maybe the area concerned is not big, or the impact on other people will not be that great, then they will not be handled as priority cases, given limited resources. We have make the necessary arrangements for deployment or training. Ms. Lam can perhaps supplement. And sometimes we can combine and streamline the different processes. For example, when our colleagues go out to inspect upon receipt of a complaint, and then the notice can be prepared in advance, and then if illegal occupation is confirmed, then the notice can be put up right away.
So that would save manpower and also the time. Instead of carrying out 2 or 3 inspections before we put up the notice, we can do that right away. All right. So usually you will have to adopt a multi-pronged approach with the assistance of technology, right? Yes, in terms of technology, we do have an information system which is in place, and we are tidying it up and also updating that. So that's the land administration information system. So we have registered all the relevant cases, and we will also be monitoring the progress closely. Well, in the past, there might have been some specific cases, so please do supplement the information to us. Next, Ms. Sito. Thank you, Chairman. Well, the Audit Commission released a report 2 or 3 years ago, and at the time, it was found that in the new territories there were many cases of unlawful occupation of unleased land, and it was very, very difficult to follow up on that. And the audit director also criticized that the law enforcement action was not quick enough. And of course, you had manpower problem because some of these sites were located within country parks, and they might have been hidden by bush and trees and so on. So even if you try to conduct inspection, you might not have been able to have access to those places. That's why you might not have been aware of the unlawful occupation. But then you have Google Map and also the GPS system, and therefore I hope that you can make more use of IT to find out if government land has been unlawfully occupied. That would also save some manpower. But then even if there are problems, well, I'm giving you a chance to let us know. In particular, the FS is asking us to reduce the overall spending by 1% by policy bureaus and departments. So where would the money be used? So given the fact that we have such a huge surplus, so does that mean that if there is a downturn in the economy, you're going to lay off people? So please let us know if you have difficulties. I think we should support you where you need more manpower. I noticed that in paragraph 4, you said that there were 6 cases whereby the maximum fine was imposed. And in one case, the occupation was less than 1 square meter. So how come it's so small? So if it's such a small area in the new territories, why do you have to impose such a hefty fine? Would it amount to an abuse of power, or is it that you fail or refuse to settle it by mediation? And also, we also have this LLC report on adverse possession. So it's a consultation document, and that follows on the point made by Mr. Ip Kwok Him, because in the new territories, sometimes the title is not clear. So in the LLC report, the boundaries of the land boundaries are not clear. So at the time of the land transaction, well, the buyer and the vendor would just conduct an inspection, and then they would try to demarcate the boundaries for a particular site. But then if the vendor thinks that he has the title of that particular piece of land, and as a result he might have sold the unleased government land to the buyer, and then subsequently if you find out that it's unlawful occupation of government land, then where there is dispute, then you will also have to deal with that in conjunction with the LLC report on adverse possession. So do you have any plan to respond to the LLC report, so that you would be moving amendments to the law so that in the new territories the land title will be clarified before you can enforce the law? All right, 3 questions. Thank you, Chairman. I'll respond to Ms. Ho's point about the LLC report. For the time being, we are still studying the report. Concerning the report, as the Honourable Member just pointed out, on the land boundaries is very important, because to determine whether or not there has been adverse possession and how big is the site, we have to look at the land boundary, and apparently it's not about the period of occupation. So for government, as far as government land is concerned, they will have to occupy it for at least 60 years before they can claim adverse possession. It's not like private land. So that is an issue that we will have to look into, and for the time being we do not have any specific amendments to propose because we haven't completed the review. But then on this occasion we are just increasing the maximum fine, but then it's not directly related to the issue of adverse possession. With regard to precedent or past cases, I'll defer to my colleague. With regard to the occupation of less than 1 square meter, Ms. Lam, I believe that here we are talking about some metal gate. It might have been erected on government land. That's why we have to put up a notice asking the owner to remove it. As to how you can make use of IT to identify such unlawful occupation, so you can give us more details later. Yes, Chairman, I'd like to ask a very short question on adverse possession. Okay, if they are already occupying it, then of course they will have to deal with the administration and you will have to resort to your own system. But then if it's an owner selling a site on government land, and if the buyer inadvertently buys in a piece of land without knowing that it's government land, and then subsequently if it's found out that he is unlawfully occupying government land, then what happens? So how are you going to deal with that? Who else would like to ask in the first round? Second round, Wu Chi Wai, because just now there was a question that has not been answered. So would you like to supplement before you invite the administration to respond? Thank you, Chairman. On the one hand, I'd like the administration to respond to this point on private land and where there are breaches on of the lease terms. How are you going to enforce it? And I've also got some specific cases. I'll give you the details after the meeting. Why has it taken so long to enforce it? And on our land, generally speaking, there is no specific marking. In particular, in a vast piece of land, there is no indication as to the land boundaries of government land and private land. So what would you do? So by the time when your staff arrive at a site, are there any ways for you to tell or distinguish if this is the boundary for a particular site and which is private land, which is government land? Do they have instruments or so on, or do they have to just take the measurements and then go back and check it? Well, before we go out to conduct any inspection, we have to prepare the land status maps telling us which is government land, which is private land. So by the time when we arrive, we will just follow the map, and then we'll be able to tell if a particular site is on government land. But then in some cases, if it's not clear, or if it's not well demarcated, then of course we will have to come back to our office to double check. But then basically we'll bring with us the status map, and then we'll be able to tell if it's private land or government land. So if it's so what about private land? How do you enforce the law? Well, we will have to follow the land lease, because there is always a land lease regulating the use, and if there are any breaches of the lease terms, then we'll issue a warning letter asking them to cease the unlawful or cease the breach within 28 days. And if they fail to rectify it within 28 days, then we will consider imposing an impingement. There are many cases, so we will have to set priorities before taking further action. So that's about the lease. So from the time when the title is impinged to the time when the site is recovered and resumed, how long will it take? It depends. And if it's a serious case, then of course we will resume the land right away. But then if it's not a very prevalent problem, then we will have to follow the priorities and also the manpower for a particular district. Yes, I'd like to supplement. On the basis of what Ms. Lam just said, I can give you a more recent case to illustrate the point. I believe that members might be talking about some unauthorized structures on private land, and that's also one of the priority areas of the Lands Department in terms of enforcement. So when the Lands Department staff went out, and if they found out that there were breaches, then they would immediately put up notices, and they would also give them a specified time for rectifying the problem. So usually these are more serious cases, and the time limit would be shorter, and if they fail to take action, then they would impinge the title. And then afterwards, they would start the process of land resumption. And for a relatively straightforward case, it will take about 3 or 4, 5 months before the process can be completed. If you want to know more with regard to some recent cases processed by the Lands Department, I can provide you with the details. And of course, I would welcome that. Well, I asked 2 questions. They are all about the chronology of law enforcement action, because in the past there was this phenomenon. All right, you might put up a notice, but then they would just continue with the occupation. And of course, if you increase the penalty, in principle, the penalty will have to be increased as time goes by, in order to maintain the deterrent effect. If you're not able to catch up with time, then to a certain extent, the penalty would just be there in name, without any substance. That's why, with regard to the 2 sites involving the breach of the lease terms, and also on the law enforcement chronology, you will have to give us a clear chronology of events, so that we can have something to base on, instead of allowing things to happen like they are right now. That is, a lot of the emphasis would be placed on the staff of the Lands Department, and they're having a hard time as to what they're expected to do in enforcing the law. And sometimes there are a lot of gray areas, and that would make their life very difficult. So the most important thing is about the law enforcement procedures. Will a very lengthy time be given to the suspected offenders and so on? That would also affect the effectiveness. So, Ms. Choi, can you supplement? Thank you, Chairman. Well, allow us to organize the steps involved. As my colleague just said, we can provide you with a typical flow chart. It's difficult to give you a definitive flow chart because it depends on the merits of the case, the background, and so on. Indeed, individual cases might vary, but then we'll be more than happy to provide you with a flow chart and also some recent cases. And of course, we will cross out the privacy information, and that would also be good for your reference. Yes, I understand that there might be special cases, but then what we'd like to know is the general flow chart. Yes, I think some members are concerned about how the discretionary power is exercised, because with the increase in penalty, that would also impact upon how you use your discretionary power. So in your consideration, who is going to make the decision, so on and so forth, all these are what we are concerned about. Next, Paul Chair asking for the first time. Yes, in the past, the penalty has been inadequate. That's why I support that we should increase the penalty in order to achieve a better deterrent effect. But then when it comes to actual enforcement, from 2008 to 2013, there were only 67 prosecutions and only 58 were convicted. And what's more puzzling or disturbing is that the fine has been on the low side, just $4,700 on average.
Of course, it depends on the seriousness of the case. For example, in one case, it's just 1 square meter, or the land can be up to 4,600 square meters, so the differences can be very big. I wonder if you would inform the court of the factors to take into account. For example, for UBWs, illegal structures for profit, of course, the penalty should be higher. What about other factors? The size of the land, the use, whether there's a track record of offense, or whether it's a continuous offense. Well, we have a continuous offense for UBWs, but usually the court will just impose a lump sum fine instead of a daily fine. So in terms of the levels of penalty and whether a continuous offense should attract a proportionate fine, would you provide more factors to the court for consideration? As for the penalty for the daily or continual offense, we have to provide the court with the relevant circumstances and factors. But the cases are all very different. Therefore, having considered the situation, we want to give more room to the court to come up with a judgment. One consideration may be whether it's for profit or not, and secondly, we would consider whether it's a repeated offense. These are more clear-cut factors. Other factors such as the size, the impact on other parties. In the background information provided to the court, information on the size of land occupied will be given to the court for the cost consideration. And whether the court would impose a heavier fine or not, well, it's up to the court. One of the reasons that we want to increase the maximum penalties is that, well, it's just, at present, it's just 10,000. And the court would take into account the maximum and then make some adjustments in imposing the actual fine. If we increase the maximum fine to $500,000, then the court would have regard to this maximum level in making its judgment. Mr. Porcher, any supplement? Well, the member has referred to the continuous offense concept. It's in the audit report, and that's why we have proposed this in the bill. And the Deputy Secretary has already stated that each case is different, in its own way different, and we want to tackle the general problem. We don't want to impose unnecessary constraints. In submitting information to the court, all relevant factors will be mentioned, such as the size of the land occupied, whether there are structures erected. All such information will be submitted to the court. We believe this is effective as a law enforcement mechanism. Turning to the seemingly low number of prosecution, I would like to say that the Lands Department, in tackling illegal occupation cases would have to adopt different procedures. In some cases, they can be handled through just one or two steps, one or two processes, and they never reached the stage of prosecution. But it doesn't mean that prosecution is ineffective. We have referred to the PAC report and the Director of Audit's report. We need to take prosecution action in certain cases, and we also need to increase the penalties to make them a better deterrence. And we need to do a better job in public education. If you just look at the prosecution figures, you may not be able to get a full picture of land law enforcement. Mr. Law, we are talking about cases whereby government land has been occupied illegally. It's an offense to do this. It would not change the fact that it's an offense if you take action, if you move out after notice is put up. So if you find out there's a case of illegal occupation for some period of time, you didn't notice that, of course, when it comes to your notice, you want to rectify the situation, and it's done. Is it because they don't want to shoulder any responsibility of illegal occupation of government land that they comply? Thank you, Chairman. In relation to illegal occupation of government land, there are different cases. Before the person is informed of a case of illegal occupation, then there's no offense. It's until the notice period is up and nothing is done, then there may be an offense. As regards whether it's an offense during that occupation period, that's something we need to reach to disseminate as public information in our publicity. We cannot prosecute the person, the occupier, before the notice period expires. So there's some room for the person to act. Because as some members have pointed out in the past, that the occupation was done inadvertently and without knowledge. We don't want to impose a disproportionate hardship on these occupiers. And then we have to have thousands of cases whereby the situation can be rectified within the notice period. Ms. Sid Ho has raised a question. Ms. Ho is not here, but perhaps you can give us an answer. That is to say, the purchaser has bought land from the previous owner, and the land is partly the government land. What kind of responsibility would the new owner be shouldering? Well, there are cases which are more complicated. Ms. Lam perhaps can help us here. Well, we encourage the buyer to seek professional advice. That will be touched on in our new APIs. If professional advice is sought, it will be easy to tell that a part of the land is government land. Maybe the previous owner was granted a short-term tenancy. There will be information to tell the purchaser, and so they will not be caught inadvertently. Well, I say if it's done without knowledge, and there was no notice put up, and so the person is not in violation of this bill, and you now want to increase the penalties. We haven't done so in 4 decades. You want to make it a better deterrence, and you want people to pay more attention to such offenses. And if you seek legal advice before you buy land through a lawyer or some other professionals, you'll be able to tell whether everything is in compliance with the law. All right, members, further questions? Chairman, Mr. Chanakan asked a question on the penalty for continuous offense. I want to make sure that I haven't misunderstood anything. So you give them some time for rectification, the offender some rectification, and of course it's an offense if it's not ratified within the time period, and the continuous offense starts to count once the time allowed expires, and until the time the case comes before the court. And the court would have regard to the maximum fine. It's $500,000. And after the time after the time limit expires up to the time the case is before the court, would that be the time frame for the framing the continuous offense? Well, the idea is that if there is an illegal occupation of government land, then the court would consider imposing a fine from $1 to $500,000. As for the fine for continuous offense, we would make a provision in the bill so that the court can impose another fine on this basis. It depends on the evidence. If there is sufficient evidence accepted by the court, then the court would consider the period the day after the expiry of the time limit for ratification, and then count the days. And it's done on the basis of the number of days, and whether it should be a 1/10 of a maximum penalty, it will depend on the court. The court can decide whether it should be $10,000 a day. So the fixed fine may be of a certain amount, but the daily fine may not be on the same basis. We propose the maximum fine is to be raised to $500,000, and the maximum daily fine is 1/10 of the maximum, that is to say $50,000. But the court is not bound to calculate the daily fine on the basis of 1/10 of the maximum. It's up to the discretion of the court. It's not stated in the law. There's no formula in the bill. No. We don't have that in the bill. It's just the maximum allowed. I think the court would consider the circumstances, the nature of the case in question. It's up to the judge.
Any further follow-up questions? If not, then... Well, just now I mentioned the issue of manpower, and Ms. Sid Ho also said that within country parks, sometimes it's difficult to identify where there might have been unlawful occupation of land. And you said that you would be making use of IT programs so that there would be a database and the accuracy can be ensured and efficiency can also be enhanced. So can you supplement the details here? Yes, I'll say a bit more about country parks. For example, the AFCD does have many teams of staff responsible for inspecting country parks. For the rest, we would also be making use of modern-day technology to assist us in our land administration work. For example, we will be taking more aerial pictures and also some mobile devices and iPads to help us in our work. I think members are also concerned, and if technology can help. In fact, I've also received messages that if there are difficulties, then members will be prepared to support an increase in resources to help you. Because other than increasing the penalties, I think there is a consensus that that would also help achieve a better deterrent effect. But then in terms of management, members are also in support of giving you more resources. I think members are very concerned about these problems. And of course, here we are discussing the amendment bill, and therefore we should be focusing on the amendment aspects. But I think the message is loud and clear. Any more questions? If not, then we still have more time to go. But then just now, we asked some questions, and the administration might need to collate the figures. And members are very concerned about that. So can I suggest this? On the issues raised by members, we hope that members can be given a written reply by the administration. And if members have no objection, then can I suggest that the next meeting be held on the 11th of November. It's a Tuesday at 4:30. As the administration will have to furnish us with further details, so at the start of the next meeting, we will see if members have any follow-up items to raise. And if members are happy, because for this particular amendment bill is relatively simple, so if there is no objection, then we can then move on to clause-by-clause examination. So that's my proposal, and of course that depends on the response from the administration and whether members have any further follow-up questions to ask. So if time permits, then we can move on to clause-by-clause examination next time, because after all, we are just updating the penalty after 40 plus years, because the current situation is very different from what it used to be some 40 plus years ago. So there is a need for us to adjust the penalty level to keep abreast of time. All right. If there is no further question, then I'll adjourn the meeting. Thank you.